The right to be told why you're being arrested. This one sounds obvious, but it's more powerful than most people realize. Under the Fourth Amendment of the U.S. Constitution, law enforcement cannot arrest you arbitrarily. They must have what's called probable cause, a reasonable belief based on facts that you committed a crime. And when they arrest you, they must inform you of the charges against you. This isn't just courtesy, it's constitutionally protected. Now, here's the critical part. If you are stopped and you are not sure whether you're actually being arrested, you are legally allowed to ask, am I being detained or am I free to go? That one question matters enormously, because if a police officer says you're free to go, you can walk away, and you should, calmly, without running, without argument. But if they say you're being detained, that is the moment your rights kick into full effect. The important thing to remember here is this: knowing your rights starts before the handcuffs. It starts the second you realize you're not free to leave. The right to remain silent. This is arguably the most important one on this entire list. This comes from the Fifth Amendment, and it is absolute. You cannot be legally punished for choosing not to speak to law enforcement. But here's where almost everyone gets it wrong. The right to remain silent does not activate automatically. You have to actually invoke it out loud, clearly. The Supreme Court ruled in Bergwe v. Tompkins in 2010 that simply staying silent is not enough. If you sit in silence for 2 hours and then answer one question, everything you said can be used against you. So the correct thing to say, and you should memorize this, is I am invoking my right to remain silent. I will not answer questions without a lawyer present. Say it once, clearly, and then stop talking. It doesn't matter how innocent you are. It doesn't matter if you think you can explain your way out. Studies show, and this is documented, that people who speak to police without a lawyer present are significantly more likely to be charged, even when they're innocent. Former federal prosecutors have said publicly there is almost nothing you can say to police that will help you as much as it can hurt you. After you invoke your right to remain silent, the police must stop questioning you. If they continue asking questions after you've clearly invoked this right, your attorney can later use that as a basis to suppress anything you said. Silence is not guilt. Silence is wisdom. The right to an attorney. This comes from the Sixth Amendment, and it is one of the most powerful protections in the entire legal system. The moment you are arrested, you have the right to speak with a lawyer before answering any questions, not after, before. And if you cannot afford a lawyer, and this is the part most people don't fully understand, the government is required to provide one for you, free of charge. This is what a public defender is. Now, the quality of public defenders varies dramatically by state and county. Some are excellent, some are overworked and under-resourced, but the right itself is absolute. Here's what you need to do. As soon as you are placed under arrest, say these words clearly. I want a lawyer. Not maybe I should get a lawyer, not should I call a lawyer, just I want a lawyer. The Supreme Court has ruled that any ambiguous request for an attorney can be ignored by police. So be direct, be unambiguous. Once you say those words, all police questioning must stop immediately, and it cannot resume until your attorney is present. This right, the right to counsel, is so fundamental that if police violate it and you say something incriminating, that statement can potentially be thrown out of court under what's called the exclusionary rule. Know this right, use this right. The Miranda warning rights. You've heard them in every crime show, but most people don't actually understand what they mean or when they apply. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. These come from the landmark 1966 Supreme Court case Miranda v. Arizona. Here's what most people get wrong. Miranda rights only apply when two conditions are both true. First, you must be in police custody, meaning you're not free to leave. Second, you must be undergoing interrogation, meaning police are asking you questions intended to produce incriminating responses. If both of those are true, police are constitutionally required to read you your Miranda rights before questioning begins. But, and this is crucial, if police arrest you and don't read you your rights, it doesn't mean your arrest is automatically invalid. What it means is that anything you said during that unwarranted interrogation may be suppressed in court. The arrest stands. The unwarranted statements may not. This distinction matters enormously, and it's something defense attorneys use regularly to protect their clients. The right to a phone call. This one is often misunderstood, and it varies more by state than most people realize. Federally, there is no specific constitutional amendment that says you get one phone call. However, virtually every state has laws requiring that arrested individuals be allowed to make at least one phone call within a reasonable time after arrest, typically within a few hours of booking. In California, for example, the law requires that you be allowed to make 3 phone calls within 3 hours of arrest. What you should do with that call? Call a lawyer or call a family member who can contact a lawyer on your behalf. Do not use it to explain yourself. Do not use it to call the victim of the alleged crime. And be aware, calls from jail are almost always recorded, with the exception of calls to your attorney. Those are protected by attorney-client privilege. So, if you call a friend or family member, say nothing about the details of what happened. Just tell them where you are, what facility you're in, and that you need a lawyer. That call could be played in a courtroom. Treat it that way. The right against unreasonable search and seizure. This comes from the Fourth Amendment, and it is one of the most litigated rights in American legal history. In general, police need a warrant to search your home, your car, or your personal belongings. A warrant must be issued by a judge and must describe specifically what is being searched and what is being looked for. But there are several major exceptions to the warrant requirement that you need to know. The first is consent. If you say, yes, go ahead, police can search without a warrant. And here is the key thing. You are never required to consent to a search. You can say clearly and calmly, I do not consent to this search. This doesn't stop them if they have another legal basis, but it protects your rights legally if they proceed anyway. The second is plain view. If police are lawfully somewhere and they see evidence of a crime in plain sight, they can seize it without a warrant. The third is search incident to arrest. When you are arrested, police can search your immediate person and the area within your immediate reach without a warrant. This is to protect officer safety and prevent destruction of evidence. The fourth is exigent circumstances. If police believe evidence is about to be destroyed or someone is in immediate danger, they may enter or search without a warrant. Knowing these exceptions doesn't just make you informed, it tells you when to say, I do not consent, and when to let your attorney challenge the search in court. The right to be treated humanely. The Eighth Amendment prohibits cruel and unusual punishment, but your rights during the arrest process itself come primarily from the Fourth Amendment's requirement that use of force must be reasonable. Police are permitted to use reasonable force to effect an arrest. They are not permitted to use excessive force, meaning force that goes beyond what a reasonable officer would use in the same situation. If you are injured during an arrest due to excessive force, you have the right to pursue a civil rights lawsuit under 42 U.S.C. Section 1983, a federal law that allows individuals to sue government officials, including police officers, for civil rights violations. Additionally, once you are in custody, you have the right to basic necessities, food, water, medical attention if needed, and protection from harm by other inmates. If you have a medical condition, you are legally entitled to receive medical care while in custody. Denial of necessary medical treatment in jail or prison is a constitutional violation. Document everything. If you are injured, request medical attention immediately and make sure it is documented. The right to a speedy trial. The Sixth Amendment guarantees that if you are charged with a crime, you have the right to a speedy and public trial. What does speedy mean exactly? The Supreme Court has not defined a specific number of days, but the Federal Speedy Trial Act requires that federal trials begin within 70 days of indictment. States have their own versions of this law. Why does this matter? Because without this right, the government could arrest you and leave you in jail indefinitely without ever actually proving you did anything. The speedy trial right protects against excessive pretrial detention, prevents evidence from going stale, and limits the ability of the government to hold charges over your head as leverage. If your right to a speedy trial is violated, your attorney can file a motion to dismiss the charges entirely. This is a powerful remedy, and it has worked. The right to know the evidence against you. This comes from a legal concept called discovery, and it is one of the most critical tools a defense attorney has. Once you are charged with a crime, the prosecution is legally required to share with your attorney all evidence they plan to use against you. This includes police reports, witness statements, video footage, forensic results, and more. But it goes further than that. Under a landmark Supreme Court ruling called Brady v. Maryland, prosecutors are also required to disclose any evidence that is favorable to you, even evidence that might help your defense.
Even if they weren't planning to use it. Failure to disclose Brady material is a serious constitutional violation and can result in convictions being overturned. This is why having a lawyer who knows how to conduct discovery is so critical. Evidence that was never disclosed to your attorney, evidence that could have helped you, may be the difference between a conviction and an acquittal. You have a right to see what they have on you, and a good attorney will make sure they show you everything. The right to bail. The Eighth Amendment prohibits excessive bail. This means that bail, the money you pay to be released from jail while awaiting trial, cannot be set at a level that is designed purely to keep you locked up if you're not actually a flight risk or a danger to the public. Now, the system has significant problems here. In practice, bail is often set at amounts that are completely unaffordable for low-income defendants, which effectively punishes people for being poor before they've been found guilty of anything. But as a legal right, you are entitled to a bail hearing. At that hearing, your attorney can argue for lower bail, for release on your own recognizance, meaning no money required, or for alternative conditions like electronic monitoring. Factors courts consider include your ties to the community, your employment history, whether you have family in the area, your criminal history, and the severity of the charge. If you cannot afford bail, you can use a bail bondsman, who typically charges 10% of the bail amount as a non-refundable fee, or your attorney may be able to get the amount reduced at a bail review hearing. Being held in pretrial detention before you've been convicted of anything can cost you your job, your housing, and your family. Fighting for reasonable bail is not just a legal strategy, it's a survival strategy. The right to a jury trial. For serious criminal charges, specifically those where you face more than 6 months in prison, the Sixth Amendment guarantees your right to have your case decided by a jury of your peers. That jury must unanimously agree, all 12 jurors, that you are guilty beyond a reasonable doubt before you can be convicted. That standard, beyond a reasonable doubt, is the highest evidentiary standard in the American legal system. It exists specifically to protect innocent people from wrongful conviction. You also have the option to waive your right to a jury trial and instead have your judge decide your case alone. This is called a bench trial. In some cases, particularly when the facts are highly technical or when a jury might be emotionally biased, a bench trial can actually be the smarter strategic choice. That decision should always be made with your attorney based on the specific facts of your case.
So there you have it. Every right you have when you're arrested in the United States. These rights exist because people fought and in some cases died for them. They are yours, but they only protect you if you know them and you use them. The most dangerous thing you can do when you're arrested is panic, start talking, and hope everything works out. The smartest thing you can do is stay calm, invoke your rights clearly, ask for a lawyer, and say nothing else. Write that down. Share this video with someone you care about, because the moment you need this information is not the moment to be searching for it. We'll see you in the next one.